All right, guys, you are officially in week 4. Okay. And this week is all about defense attorneys, which are a vital piece to the court puzzle that exists in every state of the United States of America. Now, in full disclosure, I was a defense attorney, specifically a defense for anybody who received a paycheck from the city. I was a city associate attorney. So, again, if anybody brought a lawsuit against anybody who received a paycheck from the city, I was their attorney. So that included everybody from police officers, correctional guards, all the way to the bus driver, right? A whole wide scale of individuals. So throughout today's lecture, which will be short and sweet, because I really want you to focus on the documentary that I've shared with you all this week, instead of listening to me rattle on too much. But I'll sprinkle in some experience and some stories to kind of highlight some of the issues within our system. So we'll look at the role of the defense attorney, legal training of defense attorneys, ethical obligations of defense attorneys, and including investigative work. Because as defense attorneys, if you have the resources, part of your role is to investigate the case to determine if the allegations against your client have any merit and how you can best serve as your client's zealous advocate. If you cannot represent your client as their zealous advocate, then you should recuse yourself. And I've had to recuse myself from 2 cases, which I'll talk about here in a second. But first, let me share with you an example of somebody who loves their job and has come up with one of the best defense attorney commercials that I have seen to date. So hopefully YouTube won't take this down. Let me go ahead and share with you this video. And again, I hope that it shows on your end. So I will share it now.
Brian Wilson, Texas Law Hawk. Brian Wilson, the Texas Law Hawk. Hounds of justice. Due process. Due wheelie. Who's hot out here? Brian Wilson. El Halcon de la Ley. Brian Wilson, the Texas Law Hawk. Hey, guys. Well. It's no refusal weekend, so you have to blow. Otherwise, you're gonna lose your license. These things are 100% accurate. Surprise, failed. No. Yeah. What just told me? That's why you don't blow. Brian Wilson, the Texas Law Hawk. You or a loved one been arrested? So called Brian Wilson, the Texas Law Hawk today.
Now, isn't that amazing? So let me make sure I have that turned off because I don't want that to come up loud and proud. Okay, so let me go ahead and reshare my PowerPoint. But that is, to me, a fantastic example of somebody who loves their job and is reflecting the role of a defense attorney. Is you got to be the hammer. You have got to serve as that person's voice, in large part because you're the expert. They're not. They may say something to incriminate themselves and bury themselves in a hole that they can't get out of without your help. So the role of the defense attorney, again, is extremely important because you're serving as a protection. You're their Superman or woman, ensuring that the court does not violate any rights, ensures that procedure is addressed and addressed properly. And if anything is violated again, you're the voice that calls it out, right? So I hope you enjoyed that. And I hope that if you are going to go the law school route, that you have fun and enjoy your job, like obviously he does. So let's look at a very important constitutional amendment. The 6th Amendment of the United States Constitution says, and read it with me, guys, In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and, drumroll, to have the assistance of counsel for his defense. So remember that concept I taught you last week about selective incorporation. Remember, the founding fathers and the 13 colonies were obsessed. They were horrified of another monarchy, no more kings, right? They wanted that out of the way. So the constitutional amendments, again, did not apply to the states. They only apply to the federal government. And in order for these rights to be plunked onto a state, they had to be selectively incorporated. So it is this following case right here, and let me move my head, in which introduced and had applied to the states that not only do you get an attorney for a federal offense, but you also get an attorney if you've been convicted, or not convicted, but charged with a state level crime, okay? So this picture is famous, and it reflects these group of young African-American boys, because most of them were very young, the youngest one being 13, and they're known as the Scottsboro Boys, okay? So the case is quite sad. In this case, there are 9 Black young men in 1931. So this happened a year before it reached the Supreme Court. So these young men were on a train, and they got into a fight with 7 white men and 2 women. When the fight broke out, all the white men were thrown from the train, right? So they're kicked off, which is rare. Think about this. This is 1931, and they kick off the train the white men. So the women ended up accusing the Black men of rape, although one has later, and by later, I mean just within the past like 8 years before her death, recanted her accusation, saying that they lied. But at the time, they accused the young Black men of rape, and all the defendants, except for one who was 13 years old, Roy Wright, who is depicted in this picture, I believe right here, were sentenced to death. And it was in a series of 3 one-day trials. So 3 one-day trials of these young men resulted in them, each and every one of them, being convicted to death, okay? So the defendants ended up, after they were convicted, to being under military guard, because there was an actual mob outside the courthouse that wanted to engage in lynch justice, meaning hang them, okay? So what's interesting is that they weren't told they could hire lawyers or even contact their families, okay? So imagine this. You're 13, 14 years old. You've been accused of a crime, and within 3 days, you're convicted to death. And you don't have an attorney, you don't have any family support, your mom and dad may not even know that you went to court, right? So they didn't even have access to a lawyer until shortly before the trial. So right before the trial, this man comes in, and he barely has any time to get any information from any of these young men, okay? So of course they were convicted. They appealed their convictions on the grounds that the group wasn't provided adequate legal representation, right? And what's interesting is the Alabama Supreme Court ruled that the trial was fair, and used horribly inflammatory language about these young men, calling them ignorant, referring to them as basically being savages. And the Supreme Court ultimately heard this case, and they reversed the ruling, holding that due process had been violated, right? So they actually held that the trials denied due process, because the defendants here, these young men, were not given reasonable time and opportunity to secure counsel in their defense. Now, what's interesting is Justice George Sutherland, he did not rest the court holding on the right to counsel guarantee of the Sixth Amendment. He actually repeatedly implicated that guarantee. This case was an early example of national constitutional protection in the field of criminal justice. So let me put this another way, guys, because I really want to emphasize the importance, the gravitas of this case. You have 9 young men who, for all intents and purposes, if it was today, would be freshmen, sophomores in high school who are accused of rape. And within the same day, they're facing mob violence outside the courthouse. They're not told that they can hire an attorney or that they should be looking for an attorney or even told their families. They're not given that one phone call, right? Or that one ability to contact their families. Instead, they're thrown into a courtroom with an attorney who questionably hasn't even talked to any of them, and they're convicted, each and every one, to death within 3 days. That is horrifying, right? And luckily, our Supreme Court agreed, and they selectively incorporated, right? They put the little hat plunk, on the state of Alabama, as well as every other state in this wonderful country, saying if you're charged with a crime, you get a criminal defense attorney. You have that right. Now, unfortunately, and they kind of joke, because you gotta find humor in some of this, guys, is that you may have the right to an attorney, but you don't have the right to a good one. That's kind of crappy, right? So that's kind of just a brief kind of light moment. But defense attorneys have a vast amount of duties. So the defense attorney is responsible for safeguarding the constitutional rights of their clients. This includes protecting their right to due process, which, remember, what is due process? Notice and an opportunity to be heard. So you know why you're in trouble, but you get the right to defend yourself in trial, right? That's due process. Before the government can take away your life, your liberty, your property, they must tell you why and give you an opportunity to defend yourself. Bum, 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 due process. All right. Then you have the right to a fair trial by an impartial jury of your peers. And if you don't think they're impartial, remove the case. Remember, you have 2 reasons why you can remove a case, because of an alleged impartial jury not being impartial, or because it's just more convenient for everybody. So your right to a fair trial and the right to confront witnesses. This is a biggie. In the 6th Amendment, the defense attorney can compel witnesses in their client's favor. And I want to emphasize this, because nobody's happy going to court. Nobody's like, woo, I got subpoena today. Yay. It's usually like crap, right? That's usually the response people have. Nobody's happy going to court, except maybe the attorney. I was always happy. I was like, good morning. Loved it. But you have the right to confront witnesses by sending out a subpoena to compel them to show up. Otherwise, nobody would show up. You got to put a little teeth in the game in order to compel witnesses to arrive to court in your client's favor. So if you think somebody's lying, get them on the stand. If you think somebody has information to help your client, get them on the stand, subpoena them, right? Because if you ask people, if you try to compel them through, hey, you really should show up, most likely they're not going to. There's a case in New Orleans that some of you have heard me talk to you about, in which they were trying to indict the lead person in a drug ring that was known as the Black Pearl District of New Orleans, which is where a lot of heroin and crack was being trafficked in and out of that section of the city. Now, the guy that was in charge of it all, he was facing trial, and all the people that were witnesses to his dealings and his violence either were assassinated, meaning shot in the head in the French Quarter, and like their body was just found later and it was obviously an execution, or they just disappeared, meaning they weren't going to talk. So the only way in which he could be convicted, was if the witnesses were subpoenaed, meaning forced to come, and then promised some sense of protection afterwards, right? But I think in total there's 7 executions. So you've got to have that ability to compel individuals to testify, otherwise they won't, right? You also have the right, of course, to legal representation. Even the worst of the worst get an attorney. Ted Bundy, well, actually, he's a bad example because he thought he was so smart that he could represent himself. Not so smart. But Charles Manson gets an attorney. Ted Kaczynski gets an attorney. John Wayne Gacy gets an attorney. The worst of the worst get an attorney. It doesn't matter how bad of a crime or crimes you're alleged to have committed, you get an attorney. That is a cornerstone foundational right. And a good story to think about in regards to that, because some people are like, why do we have to pay for their representation? It's because you are preserving democracy, meaning In the 70s, there was a lawsuit brought about by the Klan, the Ku Klux Klan, because they were pissed off because there was an area that did not want to give them a permit to march, right? And I kind of get that. Nobody wants to hear them, right? But a Jewish attorney took on their case, and people were horrified. They're like, why would you take on a case by this horrible group of people, right? And he said, listen, they have a First Amendment right. And if they are silenced today, who's going to be silenced tomorrow? And that kind of indicates the importance of it's bigger than us, meaning our constitutional rights, our guarantees are bigger than us. We've got to preserve them for everybody, even the worst of the worst, because that is our right as citizens to these cornerstone foundational protections that are in place for us, right? And if the system works as well as we think and hope and pray it does, then the guilty will see their day, right? That's the hope. Now, whether or not it's perfect, it's not. It's not perfect. There are tons of issues in our criminal justice system, a lot. But the goal is to be as good as one can be, right? And again, always room for improvement. And goodness knows we have a lot of room for improvement. So, as I mentioned in the last lecture, a lot of people cannot afford an attorney. And this is where an indigent defense attorney comes in, which is otherwise known as a public defender. So when you see the term indigent defense, that's the same thing as a public defender. So at the end of their case, approximately 66% of felony federal defendants and 82% of felony defendants in large state courts were represented by public defenders. That's a lot of people. And when I was your age 100 years ago, my criminology professor said something that stuck in my head all these years later. He said the most important color in the courtroom is not black or white, it's green. Meaning, do you have the money to afford private counsel? And not just private counsel, but good private counsel, right? And that's an issue even today, 2023, over 20 some odd years later, it's still an issue, and it probably will continue to be an issue. Because at the end of the day, who pays public defenders? The taxpayers. And so if we want them to have more resources, if we want them to have more time to better prepare and represent their clients, then we have to raise taxes. But when it comes down to the constituents, us voting on those things, and you're asked when you vote, do you want increased taxes to support indigent defense? What do most people vote? No way. I'm not paying higher taxes for them, right? So it's a circular issue, a circular problem that plagues pretty much the entire country still. So there's a lot of indigent defense issues, such as heavy caseloads. They have tons of people under their belts that they have to represent. They have limited resources. Public defenders on average make between $45,000 and $60,000 per year. Even if you've been practicing for 20 years, that's the ceiling of how much you will get paid, meaning that's the most. So they get paid very little. And there's a lot of pressure to resolve cases. In fact, there's a local attorney here in Corpus. Her name is Lisa Greenberg, and she's awesome. And she has mentioned several times when I've spoken to her about how when she was doing a lot of indigent defense work, and she still does, by the way, that judges would not want her on a case because they knew that she wasn't going to plea bargain the case, that she was going to push it to go to trial. Not many public defenders do that. So there's a pressure to get rid of cases before they even reach trial, to get rid of them through plea bargaining, right? So, and there's also an issue with information asymmetry. So you're probably saying, what the heck is that? I hope you're asking that. So this is because the public defender has such little resources and time. They may lack information about how good is the prosecution's case. Does the prosecution just have one witness and that witness was high as a kite when they allegedly saw the crime happen? Or do they have 10 witnesses, including a priest, right? That matters. So the public defender may lack that information on the front end of their case. And so they may be more apt to just trying to push their client into a plea bargain type of situation. And there's also, along those same lines, a disparity in bargaining power. The prosecutor holds the cards, guys, when it comes to offering a plea bargain, telling the defense counsel what they have, what they don't have, the strength of their case. They're not going to give away their case at the front end. They're going to make it sound like they have a slam dunk case every single time, and that this plea bargain is a gift, right? So there's definitely a disparity in bargaining power. And there's also an impact on the innocent. So you'll get to tackle that in more depth in this week's discussion question. But to explore this a little bit more, think about this. The Innocence Project, which is a nonprofit organization, found that since its inception, of coming into fruition, they found over 375 people have been exonerated from death row because of DNA evidence, meaning we have had over 375 people that were innocent that could have been put to death that otherwise would have been put to death had it not been for this organization. So the criminal justice system failed them, right? And that's not a mistake you can get back. You can't say, whoops, sorry, Bob. You can't do that, right? That's a permanent mistake. And when you look at the National Registry of Exonerations, they went through a whole comprehensive list of exonerations, and they found that as of 2021, there have been more than 2,800 exonerations since '89. These exonerations involve cases where individuals were found to be factually innocent, often due to DNA, recantations, or other newly discovered evidence. And then even studies, when we look at studies that have examined this, in 2014, they found that 4.1% of defendants sentenced to death in the US are actually innocent. Okay. So this week, I have you looking at a specific case called the hot coffee case. And it is a fascinating look. Now, most of you are too young to remember this case, but it was all over late night television. Jay Leno, David Letterman, when they were big on TV, would make fun of this case all the time. And the joke was that there's this woman who is suing McDonald's because her coffee was too hot. It spilled on her and it was too hot. And so people use this as a joke. They're like, oh, you're going to sue for hot coffee. And I vividly remember this even as a kid, watching this on late night TV and thinking, oh my gosh, people will sue for everything, right? And it was used as this display of how litigation has just become out of control, that everybody's just suing for anything, right? But there was more to the story, way more. So please watch this documentary in its entirety. This is the link to the documentary. Please take notes and then be prepared to answer the questions in the discussion question forum for this week. Now, as always, you don't have to post to your classmates. Just make sure your initial post is posted by Thursday, 11:59 p.m. Okay. And then if you have any questions or issues, make sure you reach out to me. You can text me, call me, email me, come to my office. You know the drill. And otherwise, have an amazing rest of your week. All right. Bye, guys.